Hello, my name is Clint Davis, and this is my video presentation outlining my proposal for my final assignment for my constitutional law class. This presentation is based on my typed proposal that I have already submitted for my final. On the same day in 2005, the Supreme Court handed down decisions concerning two related cases in the state of Kentucky. The cases were Van Orden versus Perry and McCreary County versus ACLU of Kentucky. The issue in both cases was whether or not displays of the Ten Commandments on public property, in the case of Van Orden versus Perry in front of the state capitol in Austin, Texas, and in the case of McCreary County versus ACLU at the courthouses in both McCreary and Pulaski counties, violated the Establishment Clause of the First Amendment and were thus unconstitutional. The issue at hand was whether or not the aforementioned displays of the Ten Commandments constituted a violation of the doctrine of separation of church and state. In the case of Van Orden versus Perry, the Supreme Court ruled that the Ten Commandment monument in front of the state capitol building in Austin, Texas, could stay and therefore was constitutional. Conversely, in the case of McCreary County versus the ACLU of Kentucky, the Supreme Court ruled the displays of the Ten Commandments in both McCreary and Pulaski counties were unconstitutional and had to be removed. It was the decision of the court that the displays of the Ten Commandments at the McCreary County Courthouse and the Pulaski County Courthouse were unconstitutional with the ostensible and predominant purpose of advancing religion. I've chosen this because I feel that it's very important. I feel that the issue of separation of church and state has become twisted. It's been perverted into something that the Founding Fathers never intended for it to be. And rulings such as this have a profound impact on similar cases going forward, because, frankly, these cases never should have made it to court. They never should have been litigated at all. The McCreary County Courthouse and the Pulaski County Courthouse there in Kentucky simply were displaying the Ten Commandments to show where their society had gotten the rules and the regulations that meant that they used to draw on for many of their court rulings. In other words, they were showing that the Ten Commandments were the foundation of the very laws that the courthouses themselves, that it was their job to enforce. And I think it's that way with every establishment in the United States. The Ten Commandments were, in essence, the foundation of modern law for our modern society. And I think that these cases, having been decided as they were, put that in danger. Now, it should be mentioned at this point, though, that the Van Orden versus Perry case, the Supreme Court did rule that they could stay, as I mentioned before. But in the McCreary County and Pulaski County case versus the ACLU, they had to be removed. Since both of these cases involved displays of the Ten Commandments on public property, and the fact that those Ten Commandments were morals and that they were the basis for our laws today, this should never have made it to litigation, let alone to the Supreme Court. And as I've said, it definitely has a profound impact on similar cases going forward. And it's not a good impact. It's very important to advocate these or look upon these with a biblical worldview, as the Supreme Court should have done. Even in the case of Van Orden versus Perry, when they ruled that the monuments could stay, it wasn't really for the right reason, in my opinion. It was due to the fact that the monuments as they stood there did not constitute a separation of church and state. That was the whole basis upon which they founded their decision. Meanwhile, conversely, in the case of McCreary County versus the ACLU, they based their decision on the fact that the displays of the Ten Commandments in those counties, McCreary and Pulaski, constituted a breach of the doctrine of separation of church and state. To begin with, the separation of church and state has been perverted, as I've said, down through the ages. In a letter by Thomas Jefferson dated January 1st, 1802, he outlines the separation of church and state. And I'll quote him here. "Believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for his faith or his worship, that the legitimate powers of government reach actions only and not opinions, I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state." End quote. Basically, what Jefferson was referring to was the situation that had come about in England where the king or any sovereign should declare himself the head not only of the state government but of the church as well. That is what the Founding Fathers were speaking to when they declared an advocacy for a separation of church and state. And through the process of judicial review, it has been perverted down through the ages to where a state government can't even place a monument to the Ten Commandments on its public property. So I think and I believe that the Supreme Court should have had a more Christian and biblical worldview when they reviewed these cases. And they should have viewed this as the fact that the Ten Commandments were part of divine law, which is basically the foundation of the United States Constitution, and that is the way our Founding Fathers intended it to be. So this concludes my presentation for my proposal for my case study. I hope it's been informative, and thank you very much for your time.